Hello, Your Honor.
Good afternoon, Mr. Aldridge.
How are you today?
I'm okay.
Hello, Your Honor.
Hello. There's Mr. Roberts. Good afternoon, Mr. Roberts.
Good afternoon.
Thank you for joining us. Mr. Aldridge, Mr. Holder, maybe I recognize him. Is he the owner or managing partner for 585 North Avenue?
Yes, Your Honor. He's the, correct me if I'm wrong here, Trey, you're the managing member of the general partner of the defendant. Did I get that right?
Sort of. I'm the president of the general manager of the defendant.
Okay. I just need to know who all is on. And we've got a Lisa on. Is that someone with you, Mr. Roberts, or is that with Mr. Aldridge?
With me.
Okay. Great. Well, we are here for a potential redo of Neil Bridges et al. Versus 585 North Avenue, LLLP. And I have a motion for new trial or judgment notwithstanding the verdict that Mr. Roberts filed on behalf of his clients. He represents the petitioners. It's really more petitioners and respondents than plaintiffs and defendants, I think, as it was originally cast, but we understand who's on which side of the V. And then Mr. Aldridge is representing 585 North Avenue. And as I recall, that is the entity that owns the 3 properties on North Avenue for which Mr. Bridges contracted as a tenant to occupy 585, 595, and 611. This was originally in front of me based on the petition filed by Mr. Roberts on behalf of his clients, seeking a declaratory judgment and or injunction saying no rent is due because effectively the physical damage provisions of the leases had been triggered by the impact of COVID that, according to Mr. Roberts, had made the spaces largely unusable, or at least unusable in the manner in which Mr. Bridges had originally contracted, which was as an event space for parties or MMA events or whatever. None of that had been able to happen, and no rent had been paid. North Avenue had some, 585 North Avenue had some counterclaims and was also seeking writs of possession based on the many months of non-payment of rent. And you guys did share with me that there had been some tentative, but ultimately not fruitful negotiations of partial payment, but there was never a meeting of the minds. So the reality is no rent had been paid for many months. I entered an order, and that order, which was something that denied the petition for declaratory judgment and injunctive relief and granted the writs of possession, left the counterclaims out there to be dealt with later if that's what the parties wanted to do. That order was the subject of Mr. Roberts's both, there's a notice of appeal sitting out there, but also a motion for new trial or JNOV. That's what we're going to talk about today, not the notice of appeal. And we also need to address 585 North Avenue's request that money be put in the registry or a bond be put if I don't grant a new trial or a judgment notwithstanding the verdict. I think that's sort of where we are, but Mr. Roberts, as the movant, I'll let you go first, both setting the stage if I miss something and then letting me know why you think I ought to grant you the relief you are seeking.
And Judge, I understand this is Mr. Roberts' motion, so I don't really want to speak out of turn here. But I do want to notify the court that I've had a discussion this afternoon with my client, and we're ultimately going to be filing a motion tomorrow requesting that the court vacate its order and enter summary judgment on these issues. And it's purely a discussion that I've had with my client insofar as cleaning up some of the issues in the record. And so this is a recent event, something that my client and I just discussed. And so some of this may be mooted that we're here to discuss today upon filing that motion. But I'm happy to discuss it with the court. I'm happy to allow Mr. Roberts to present his motion, but I do believe that a large portion of what we're here to discuss today is going to be mooted.
Okay, let me ask a couple questions, and I'll certainly let Mr. Roberts as well. So, Mr. Aldridge, on behalf of your client, your request, and it will all be in writing soon enough if it isn't already. It wasn't this morning, but it may be now. Your request is that I vacate the order that was primarily in favor of your client, which would mean no writs of possession. It would mean also a corollary of that would be Mr. Roberts's clients don't need to put anything in a registry right now. They may continue to owe rent for months where they're not paying and the lease continues to run, but no writs of possession, and really today no discussion about putting money into the registry. And instead you'd be filing a motion for summary judgment, which would give Mr. Roberts 30 days to respond. And then we would work through the issues that were raised in the motion for summary judgment. Is that correct?
Yes, Your Honor. We believe we have all the evidence already before the court. We may need to submit it. I need to look over what's been submitted and see if we need an affidavit from Mr. Holder or not, but just certifying the evidence that's before the court. But the court has stated everything correctly.
And so I'm clear, it would be vacating not only the writs of possession, but also the order that denied the request for declaratory judgment and denied injunctive relief. I wouldn't suddenly grant declaratory judgment, but I would step back and we would be in a posture where Mr. Roberts's original petition would basically be unresolved, whereas it was essentially resolved by way of my order. Is that correct?
That is correct. And just in full disclosure to the court, I don't think that there is anything that necessarily mandates my client moving to set aside the declaratory judgment aspect of things. This is purely on the writs of possession side of things. But since we're going to be waiting for 30 days anyway, we're just going to formally ask for summary judgment on those two issues.
Mr. Roberts, what's not to like?
Well, I'm going to withdraw the notice of appeal and also this motion.
Okay. Why don't you keep those until we see the motion for summary judgment and whatever, or are you looking at the docket? Is there something already on the docket?
We haven't filed anything, Your Honor.
Okay. So what I'll do, Mr. Roberts, is say, enjoy your break. And I'm sorry we interrupted it, but I think this was a time is of the essence matter. When Mr. Aldridge files what he says he's going to file.
Your Honor, I'm sorry, my other computer froze. Could you repeat? I'm in here with the paralegal Lisa now. I'm sorry.
Okay, sure.
When I started speaking, it froze, so I didn't hear.
Okay, no problem. Yeah, you disappeared. There's just some pictures of coffee on the wall.
I ran to the other room. Yeah.
Good. So what I said was, you probably shouldn't withdraw anything yet. Let's just wait for Mr. Aldridge to file what he's going to file. Not because I doubt he's going to do it, but just keep your motions in place. When you see that Mr. Aldridge has filed these things, then I would ask you to either file a notice that you're withdrawing them or shoot an email to Ms. Niles, and I can enter something so that the docket down the road looks clear. But for now, I think your motion for new trial should remain pending, as should your notice of appeal. Then we can all digest what Mr. Aldridge filed, not in a substantive way, but just say, okay, procedurally, he's now switching gears. It's motion for summary judgment. And then if I choose to vacate my order, which I suspect I will, if the person who benefits most from it is saying, no, I don't want that right now, or at least not in that form, then I'll do that. Does that work for you, Mr. Roberts?
Yes.
Okay.
Yes.
So, Mr. Aldridge, if you would let Ms. Niles and Mr. Roberts know via email, even though we all get these e-service notifications, when you file whatever you're going to file, then I can look at it and I can have Ms. Niles give everyone direction. But Mr. Roberts is free to withdraw whatever he wants. I'm not going to expect him to withdraw things until we've got something in the docket.
Understood. Makes sense.
I think we have the same concern about making sure the record is clear, so.
Okay, well, good. This is not how I expected things would go, but it's one reason why I like this job. You can't ever predict too much about it. Mr. Aldridge, we'll look for your filing. Probably won't connect with you guys in this format before Thanksgiving. Be smart and safe over the Thanksgiving holiday so you're around to continue to litigate this case.
Thank you,
All
Your
right.
Honor, you as well.
All right. Thank you, everyone.
very much. All right, bye-bye.
Ms. Niles, can you stay on?
Sure.